So the Supreme Court has decided to grant, vacate, and remand a major Second Amendment case, which is going to impact gun possession cases and all these issues about nonviolent felonies. So let's talk about what is happening. Now, before we jump into this video, I want to thank one of the new sponsors of the channel, which is Patriot Mobile. For 10 years, Patriot Mobile has been the only company in America, the only wireless provider that has Christian conservative values. Patriot Mobile offers dependable nationwide coverage, giving you the ability to access all three major networks. That means that the same coverage you would get from those companies is the exact same that you would get from Patriot Mobile. And you can also then support a company that has the same values as you, which is pro freedom of speech, pro 2A, and pro freedom. I first met Patriot Mobile over at SHOT Show. I met their whole marketing team. I got to have conversations with them, and they seemed like a really cool company. And they were actually sponsoring, SHOT Show, which is a big deal. And also, they are 100% based in the US, which means that if you need to call customer service, they're all here in the US, and I believe most of their team is actually in Texas. So I recommend that you guys check out Patriot Mobile if you're interested. You can go to patriotmobile.com/scholar, or you can call 972-PATRIOT. And if you use the code SCHOLAR, you can get a free activation fee. So again, really excited about this sponsor, a really cool company. They have the same values as us. And if you guys are interested, again, check out those links. Now, as I mentioned in the intro, in this video, we need to talk about a huge Second Amendment case that has been decided by the Supreme Court and is now impacting a lot of other cases, specifically one case that has now been granted, vacated, and remanded back down to the lower court for reconsideration in light of that Rahimi decision. The case we're going to be talking about in this video is called Range versus Garland, and it involves a challenge to the federal laws which prohibit someone with a nonviolent felony or maybe even a misdemeanor equivalent from being able to own, possess, and acquire firearms pretty much forever. Now, like I mentioned, we got that 8-1 decision in the US versus Rahimi case, and we were all anticipating what would happen with this Range case. And then we received an order list that essentially the Range versus Garland case was vacated, it was granted, vacated, and remanded back down to the lower court for reconsideration in light of what they said in Rahimi. So we need to break down what that means and what now is happening at the lower court level now that this case has been GVR'd. Now, for those not aware, this case originally came out of the Third Circuit en banc panel. It came out of the Third Circuit essentially because 26 years ago, Brian Range, the individual here, was convicted of concealing some of his income so that he could obtain additional food stamps, essentially for him and his family. Now, one of the interesting things about this case is that there is no prior criminal history, Mr. Range. He has no issues after the fact. Essentially, he just made one false statement on a government form about food stamps, and he was charged and convicted of a Class 1 misdemeanor. And because of that Class 1 misdemeanor and the potential jail time, they treat it simply in some ways as a felony equivalent, and they are using it to essentially prevent him from ever being able to acquire, possess, or use firearms essentially forever. Mr. Range brought this lawsuit originally before a district court in Pennsylvania against the Attorney General and the ATF. He sought for the federal government here to no longer be able to bar him from possessing firearms only because of that one nonviolent misdemeanor that happened 26 years ago. However, the district court on review ruled in favor of the federal government on a motion for summary judgment. Now, in doing that, the court used something known as the two-step approach. Now, this review actually happened before the New York State Rifle and Pistol Association versus Bruin case, the Supreme Court case. What ended up happening here is there were some appeals that went up, some additional review because of what happened in the Bruin case, and essentially, but still on review, the three-judge panel in the Third Circuit issued an opinion upholding that lower court decision, still citing to Bruin even after Bruin, but the three-judge panel cited history and tradition in finding that individuals who are constitutionally entitled to bear arms are only law-abiding, responsible citizens. So there was this interesting discussion about how the 2A only applies to responsible people or responsible citizens. And so here the Third Circuit three-judge panel found that Mr. Range, because of that one nonviolent misdemeanor 26 years ago, did not qualify as a responsible citizen, and because of that, he fell outside the class of people protected by the Second Amendment. Now, Mr. Range did not quit after the Third Circuit three-judge panel reviewed his case and ruled against him. He then sought en banc panel review in the Third Circuit, and on review, the en banc panel actually found in his favor. Now, in that decision, the majority discussed how their precedent had prior incorrectly used the two-step approach, which was expressly rejected by the Supreme Court in Bruin. And then they also went on to say that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people, entitled to keep and bear arms, and that our nation has no historical tradition of disarming people like him. The government responds that Range has not been one of the people since 1995 when he pled guilty to that nonviolent misdemeanor. The Third Circuit en banc panel stated that in sum, we reject the government's contention that only law-abiding, responsible citizens are counted among the people protected by the Second Amendment. And based on that, the Third Circuit en banc panel reversed the lower court's decision and ordered that essentially a declaratory judgment be issued in favor of Mr. Range. So here the federal government lost on their 922G1 arguments, and in some ways, as applied to Mr. Range, 922G1 was significantly damaged. It was significantly chipped because if you cannot apply this one federal law against Mr. Range, well then there was a high likelihood that other people would also win their challenge. Now, in response to that, of course, the federal government decided to appeal up to the Supreme Court, seeking Supreme Court review of this Range case. But the Supreme Court recently granted review to the Rahimi case and recently also decided the Rahimi case, which dealt with a similar issue, but a different section of federal law, a different section of 922, which dealt with domestic violence restraining orders and individuals being able to purchase, possess, use, and acquire firearms while they're subject to those types of orders. Now, the issue with the Rahimi case is that they were not super favorable facts. Mr. Rahimi, if you're aware, was not a very good person. He had a lengthy criminal history, and so we knew that it was probably unlikely that that would go our way. Now, the Supreme Court recently issued an 8-1 decision in the Rahimi case, and in some ways, Rahimi was narrow, but they did do some additional analysis kind of on the how and why aspect, some of the historical analogs, and what qualifies as a relevantly similar law to justify these types of federal laws or other types of two-way regulations. And so Rahimi was very important, and we knew it was going to impact what was going to happen with this Range case as well, because the Range versus Garland case was put on hold for the Supreme Court to essentially rule on Rahimi, and then we would get additional insight on what the Supreme Court wanted to do with Range. Now, after the Supreme Court issued that 8-1 decision in the Rahimi case, now also if you're interested, the only dissenting judge was Justice Thomas. He wanted a more narrow approach when it came to the Bruin analysis and a more narrow approach even looking at the Rahimi case. So he was the only dissenter, but after that decision, what ended up happening is the federal government renewed their call to the Supreme Court for them to grant review to the Range case, maybe even some other cases, and if they didn't, to either GVR these cases or only take review of the one Range versus Garland case. Now, the order list for this Range case simply stated that the petition for writ of certiorari is granted, the judgment is vacated, and the case is remanded to the United States Court of Appeals for the Third Circuit for further consideration in light of U.S. versus Rahimi. Now, one of the interesting things about all this is I don't think that the Third Circuit en banc panel is going to come out any way different from what they've already ruled. They already found that Mr. Range was one of the people protected by the Second Amendment, that he did not fall outside the text of the Second Amendment, that this nonviolent misdemeanor did not disqualify him from exercising his right to keep and bear arms. And so I don't think anything in the Rahimi case is going to change the Third Circuit en banc panel's decision. If anything, there was language in Rahimi that justified Mr. Range actually being one of the people, that he didn't need to meet this whole responsible citizen clarification that the Third Circuit 3-judge panel wanted, or some of this other language, that inherently he is just one of the people, despite even what the government was saying. Now, after the Supreme Court has GVR'd the Range case back down to the Third Circuit, we received an order from the Third Circuit en banc panel that stated that, by order entered July 2nd, 2024, the Supreme Court of the United States vacated the court's en banc opinion and remanded the case for further consideration in light of U.S. versus Rahimi. At the direction of the court, the parties are ordered to file simultaneous supplemental briefs addressing the impact of Rahimi on this matter. So really soon, we're going to get the government's arguments, the federal government's arguments, and then also the plaintiff's arguments on how the Rahimi case is impacting this Range case and how the Third Circuit en banc panel should rule in this case in light of what just happened in Rahimi. Now, like I mentioned, I don't think that the Third Circuit en banc panel is really going to change their analysis much at all. If anything, I think they're going to pull some of the language from Rahimi about who are the people, rejecting the whole responsible citizen argument that was put forward also in the Rahimi case. They're going to pull all that language and then just use it in Range to bolster their position that they got the answer right the first time, even before Rahimi, and then essentially, once again, rule in favor of Mr. Range. And then we're going to see, once again, probably the federal government seeking Supreme Court review. Now, in some ways, I think that the Supreme Court should have granted review to the range case. I think if they thought Rahimi needed to be applied directly to this range case, they should have done it themselves. I think what ended up happening is that simply at the end of the Supreme Court's last term, they decided to punt this issue and maybe address it at a later time. But for everyone concerned about the nonviolent felony issue and potentially losing 2A rights forever because of this federal law, this is the case we're going to be watching very closely going forward. So if we get any more information, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.